The housing development lobby in Florida is starting to abuse a new state law that was supposed to be about helping communities rebuild after a hurricane. Developers around the state are starting to weaponize this new legislation in a way that could gut protections for wetlands, protections for rural areas, basically any kind of attempt at smart growth in Florida or to better manage growth in Florida could be undone by the way developers are starting to use this new law. This is quickly becoming one of the biggest controversies in Florida. We'll tell you more about it in just a sec. Hello, and welcome to Seeking Rents, the podcast. I'm your host, Jason Garcia. I am the publisher of Seeking Rents, which is a newsletter in Florida about state politics, but with a particular emphasis on the ways that big businesses and other special interests influence public policy in this state. That name, Seeking Rents, comes from a term in economics called rent seeking. And rent seeking is what's happening when someone with lots of wealth and influence, like a big business or a billionaire, uses their wealth and influence to get laws changed in their favor in a way that allows them to capture even more wealth and influence for themselves, but usually at the expense of someone else. So for today's show, I think we're going to talk about a brewing storm in Florida, and pun a little bit intended there, because it doesn't actually, it's not a hurricane type of storm. It has to do with real estate development, land development, and growth management, but it is a direct offshoot of hurricane-related issues. And so earlier this year, the Florida legislature passed this sweeping kind of hurricane-related legislation. It was called Senate Bill 180. Governor Ron DeSantis signed this into law, I think it was June 26th, so just a little over a month ago. And like I said, this was a sweeping piece of legislation. There was a lot in there dealing with issues related to preparing for storms before they come, improving emergency response in the immediate aftermath, and sort of helping communities that have been hit by storms rebuild and recover in sort of more easily and more quickly in the months and years that follow a storm. There was a lot in there, a lot of good stuff. This was a piece of legislation that passed with, I believe there was just a single vote against it. There was a lot of bipartisan support. There was a lot of just really interesting stuff in there too. There was a piece of the legislation dealing with something called FEMA's 50% rule, which is a really unpopular but probably very important piece of policy involving flood insurance, where homes in flood zones, when they're damaged by floods, if the damage causes damage equal to more than 50% of the value of the home, they have to tear it down and rebuild to modern flood standards. The legislature actually put some language in there, kind of loose, giving people a way around that a little bit more. Like I said, it was interesting. I don't think it was actually necessarily bad, because there's like a good debate about whether or not how effective that policy is. This piece of it, which deals with a thing called look back periods. I won't go too far to the weeds right here, but I'll throw a link into the show notes to a story we wrote about this issue before the session began, for anybody that wants to learn more about that. But that was in the bill. There was actually, I think I've mentioned on this podcast before, we've been pulling a bunch of records related to what various special interests were working on during this past session. We're still getting some of those back, just starting now to dig through some of the ones we've got. I mean, literally, we're talking hundreds of pages of records. One of the things I just learned was there had been a provision in this hurricane legislation that seemed to have to do with ensuring truck drivers delivering essentials could get access to restricted areas at any time, like making sure that they couldn't be, if you were transporting essentials, you could go basically wherever you wanted to go. And it turns out that provision was written by lobbyists for Publix supermarkets, the grocery chain. That provision actually came out of the bill. So one of the things we'll probably spend a bit of time in the next little bit is trying to learn more about that language, why it didn't pass, that sort of thing. But like I said, there was just a lot of interesting stuff going on with Senate Bill 180, and a lot of it either good or arguably neutral and just interesting. But there was one piece of this legislation that has become just an enormous problem in Florida. And it has to do with the argument for it has to do with again, helping communities, making sure people can basically rebuild their homes after a hurricane. And stopping, cities and counties from making changes that essentially, making changes to their land development regulations and their building codes, that sort of thing, that would essentially make it impossible for someone to rebuild their home or business. And it was allegedly designed to stop that. But it was written in such a crazy, far-reaching way that, like I said, it has become an enormous problem. And like I'll throw a link into the show notes to the actual legislation, so if anybody who wants to read the actual provision themselves can see it. But it's in section 28 of this bill, and it basically says that any city or county that fell within essentially the emergency declaration for any of hurricanes Debbie, Helene, or Milton, which, by the way, that's the entire state. Everybody, I believe every single county in Florida, and thus any city within those, fell within those declarations. So the entire state, it prevents them, it preempts them. We've talked about preemption in the show, when the state level government takes powers away from local governments. It preempts cities and counties from passing essentially land development regulations or zoning changes, zoning restrictions that are, I think the language it uses, and let me throw on my glasses here to get it, that are more restrictive or burdensome than what was in existence at the time of these storms. So it's saying local governments cannot essentially adopt any kind of land development changes that are more restrictive than what was in place at the time. But most significantly, this language was retroactive. It went back to August 2024, which is when Hurricane Debbie hit Florida. And it says anything adopted since then, that is any kind of land development change, any kind of comprehensive plan amendment, all the sort of stuff all the tools you use in growth management, anything adopted since then that can be considered more restrictive or burdensome than the status quo is now invalid, which is just like an enormous thing to say. I mean, land development is most of what, like, that's like 50% of the job for local governments, growth management type stuff, land use. And again, as this bill was moving, it's so breathtakingly broad, and there's been some sort of chatter that this was somehow like slipped into the bill at the last minute. It was not slipped into the bill at the last minute. This was in there most of the way, at least through most of the House version of this legislation. So there was lots of time for people to sort of pay attention to this. And the answer that kept coming back from the Republican legislators pushing this was, again, this was about making sure people can rebuild. This wasn't meant to be some sort of sweeping preemption that stops cities from regulating growth at all, or invalidating anything they've done in the past year to regulate growth, or anything they can do up until, I think the language in this keeps this restriction in place until 2027, right? So for another year, basically it creates this like 3-year window where cities and counties can't do anything about growth management. They can't make any kind of improvements or changes to their codes to like protect wetlands, or, limit urban sprawl, or like drive higher density in any sort of like, stick way rather than carrot way. But again, the answer kept coming back that no, this wasn't as broad as it seems. This was narrow about just making sure like people hit by a storm can rebuild. Well, lo and behold, that is not how the development lobby is treating this legislation. So I mentioned that Ron DeSantis signed this bill on January 26th or June 26th. 4 days later, June 30th, at least 2 counties in Florida got threatening letters from development interests. This happened in Manatee County, where this nonprofit I believe it's called the Freedom Housing Alliance, but it's actually just a front group for the home building lobby. You look it up, the like paperwork was faxed in by the CEO of the Suncoast Home Builders Association, and if you dig into the records, you see that like it's essentially run by a bunch of developers down there. It doesn't identify the developers, but Manatee County is weirdly enough home to some of the most politically influential home builders in the state. You're talking about like Pat Neal, a former Republican senator who runs Neal Communities, I believe, or Neal Land Development. He's just a major Republican donor. There's also a guy by the name of Carlos Baruf. I think his company is Medallion Homes. He's another big donor, ran for Senate a few years back. Lakewood Ranch is a massive planned development down in kind of Manatee, Sarasota County area. Anyway, all of these guys are like big influential developers in Southwest Florida, Manatee County area. And Manatee County developers on June 30th, 4 days after this law went into effect, sent the Manatee County Commission a letter warning them you need to repeal an ordinance they had just approved raising impact fees. Impact fees are essentially a tax on new construction. These are fees you charge home builders who are building new homes to pay for essentially the infrastructure needed to serve new homes. Like, so transportation impact fees pay for like new roads serving a subdivision or accommodating the traffic that the subdivision will generate. You have impact fees for schools, for parks, for water and sewer connections, that sort of thing. But this home building group warned Manatee County that Senate Bill 180 just passed. That makes this impact fee increase illegal, and you need to repeal this impact fee increase, which is supposed to go into effect in a few months. And if you don't, we'll sue you. The same day, Orange County, where I am in Orlando, this is Orange County is where Orlando is. A prominent developer that has been litigating for more than a year now to try and overturn. For initially, it was trying to stop, and then it tried to overturn when it failed to stop at this rural boundary that I think we've talked quite a bit about on this show, that voters in Orange County approved overwhelmingly last year, that creates some new regulations that make it much harder to develop basically undeveloped land on the rural fringes of the county, kind of the far eastern and western sides of Orlando. This developer that has been fighting the rural boundary now for more than a year sends Orange County a letter saying, hey, Senate Bill 180 just passed, and if you don't repeal the rural boundary, we're going to sue you. It is illegal under this sweeping retroactive prohibition that was tucked into this hurricane recovery legislation. And and once, fortunately, neither Manatee County nor Orange County have backed down. The county commissions, they're both sort of refused to repeal their ordinances. But now, at least in Manatee County, this development lobbying group, this nonprofit funded by developers, has sued, and they have sued, arguing that 180 makes this impact fee increase illegal because of this provision, this section 28 of the bill. This is a huge deal, and there has not yet been a lawsuit filed in Orange County over the rural boundary, but this pre-suit letter is what these notifications are called, has set it up. The developer, if it fails in its bid to get the rural boundary overturned in its current lawsuits, it could very well go after it through this mechanism too. And this is a thing that like local government officials around the state are really starting to freak out about. And it is not just developers that are using this to attack things. Again, I'm aware of examples in both Manatee and Orange here, but I imagine this is happening in other places. What you're starting to find is state regulators are now refusing to approve when counties make what are known as comprehensive plan amendments, the changes to essentially their like future land use maps and stuff. They are now getting letters back from officials in the DeSantis administration at water management districts, sometimes even their own staffs, saying you can't do this because of Senate Bill 180. This is, again, both Manatee and Orange County have received letters from the DeSantis administration denying comp plan amendment transmittals. Boy, that is a nerdy thing to have said. But anyway, the DeSantis administration is blocking changes to their future land use plans essentially because the administration is saying it's prohibited by Senate Bill 180, this section of the bill that essentially ties the hands of local governments, creates this like complete inability to do any sort of land development regulation. There's another section of the bill that does this too. There's if you're one of those true sickos that's going to pull up the bill and read it, that's in section 18. It's a very similar piece of the bill. It's not retroactive, but it sets like that applies to future storms. So if any, basically creating period of time where after a storm, a government can't make any sort of changes. That, well, sort of sweeping, and the language in it is way too broad. At least that's perspective, and everybody kind of understands the rules going in. But this section 28 that goes back, that is retroactive to August 2024, and then essentially creates this 3-year window. It basically dissolves anything that's happened in the last year, and then creates this 3-year window where every county in the state is forbidden from doing anything to protect wetlands, to, improve buffer requirements, to, protect rural areas, the rural boundaries, this sort of thing. This is a huge deal. I suspect we are just now really beginning to hear more and more about this. Because again, when you think about this law has only been in effect now for about a month. We've already got one developer-backed lawsuit happening in Manatee County. It sounds like it seems very likely Orange County is about to get hit by one. As I said, regular just sort of future land use map, comp plan amendments, transmittals are being blocked. There is talk that a number of cities and counties might band together and file a lawsuit challenging this law. As I'm not 100% sure what the challenge would be. There are some pretty strong home rule provisions in the Florida Constitution, although that has never stopped the governor and legislature from trampling all over that in the past. And the more recent wave, the DeSantis Supreme Court has seemed far less interested in protecting and upholding home rule than previous iterations of the Supreme Court. But also there's, again, this language of like preventing anything that is more restrictive or burdensome. That's such a vague and open-ended subject. I mean, just raising impact fees to pay for infrastructure, is that more restrictive or burdensome land development regulations? Or is that just, that's tax policy, right? I mean, a lot of this is really vague. There has been chatter that legislators are still privately, like some of the Republican legislators that have been involved in this are kind of like privately telling people, no, this isn't how it's meant to be used, and like kind of encouraging their locals to stand up for this. But if that's true, the Republican legislators who sponsored this bill need to stand up and say that publicly. Like they need to get loud about just what specifically they intended. And they need to start calling out, if they did not intend to help the development lobby essentially defang every single land development regulation that's been approved in Florida over the last year, they need to say that. They need to get out front there. They need to start calling out some of these special interests that, if this wasn't intended, that are obviously abusing this law. If it was intended and everybody just sort of hid the ball on this, well then, throw all the bastards out, right? So, and also, this is one that I don't think Ron DeSantis is going to escape, because land development and growth management is not a partisan issue. This is one, Orange County, one of the most liberal Democratic counties of the state. Manatee County, incredibly Republican, very conservative, Southwest Florida. This is homeowners, right? These are the same people that Ron DeSantis is trying to curry favor with all his talk of like deep property tax cuts right now. These are the same people that are going to be just as furious when they find out that, they can't do a single thing to control sprawl in their areas, to protect open land or rural land in these communities right now because of this bill that Ron DeSantis signed into law. I don't think he's going to be able to run away from this. This is just beginning to boil over now, and I suspect we're going to see this get the fight over this is going, the noise around this is going to become deafening very soon, like before the end of the summer sort of thing. So anyway, it's another reminder that, you got to read bills, and also maybe don't take the legislature's word for it when they tell you when some language looks funny or looks a little swinky, and you got a bunch of Republican legislators telling you, nah, don't worry about it. Doesn't actually mean that. They might not be the most reliable narrators of the bills they are sponsoring themselves. So anyway, we'll leave it there. I'm going to throw a couple of stories into the show notes about this issue because, as I said, it is starting to bubble up in different places. So for folks that want to read more, as always, if you haven't already, just make sure to sign up for the newsletter. SeekingRentsFL.com is the easiest way to find us. Subscriptions are free. Nothing is behind a paywall, but there is an option to voluntarily pay for a subscription if you've got the means. If you do have the means, those paid subscriptions are super important. They're how we start to that's how we help pay for the public records requests like that I alluded to that we're digging into. So we just had a story recently. This didn't actually come out of my public records request. Another reporter did it and shared it, but that showed like Apple lobbying to stop some pro-consumer legislation that would have made it easier for people that own iPhones and iPads to get their devices repaired affordably. Apple secretly lobbying behind the scenes to help kill that legislation. And like I mentioned, we're learning a bunch more about some of the biggest developers in the state, some of what they were working on this past session. So there'll be a lot of stories to come on the newsletter and in the podcast over the next few weeks, I'm sure. So again, subscribe if you can. And if you've got the means, please think about paying for it. And then just, if you wouldn't mind, hit those like and subscribe buttons. That's a big help. Okay, we'll be back again soon. Take care.